You're listening to The Edge 105.1 and 105.3 FM. Your life, your music.
The Edge! Well, I'm sure there are some of you who have felt the burden brought on by crippling debts, particularly with the impact of the COVID-19 pandemic and now the global economic fallout from the war in Ukraine. With all the best will and intention in the world, you may not be able to see a clear path from under-mounting debts, and you may fear for your future with the prospect of losing your home or business to creditors. So does the law provide any protection in such a vexing and stress-filled circumstance? To help us answer that question, our guest today is Julianne Mais Cox, a partner at DunnCox Attorneys-at-Law. Julianne, welcome to Home Run. Welcome to The Edge.
Good evening, Dion. It's a pleasure joining you again on the legal landscape.
It is.
Good evening to all your listeners.
Thank you on their behalf. It's always a pleasure having you as well, Julianne, with all the information that you equip us with. So I understand that the focus today is not on bankruptcy, however, but just the mention of the word bankruptcy carries with it some negative connotation. So what is bankruptcy?
Well, you're so right about that. The word bankruptcy often carries the stigma of failure and impoverishment, and even the view that it may have some criminal element to it involving fraud. But none of those are necessarily true, Dion. But I think a little background is really needed at first. So in Jamaica, before 2015, the bankruptcy laws, which included a law dating back to 1880, did not necessarily focus on the financial survival of an individual or a company that was in debt. The focus was on liquidating assets to pay off creditors in a manner that often punished a delinquent debtor or an otherwise viable distressed company. The law did not really encourage innovation and entrepreneurship, which by definition can be risky ventures. But that focus changed from 2015 with the new Insolvency Act, which focused on debtor rehabilitation instead of, debtor punishment. The new law's objectives include preserving viable companies and strengthening and protecting Jamaica's economic and financial systems. And those are actually objectives stated in that legislation. And these are lofty goals indeed. So, yes, bankruptcy does refer to a legal process where control over bankrupt assets are taken over and administered by someone appointed for that purpose to pay creditors. However, today, with the Insolvency Act, this includes the option of a legal process that gives debtors, as that's defined in the Act, a chance instead to come to an agreement with their creditors to reorganize their financial affairs. The effect of that can be to rescue, protect, and rehabilitate debtors and even eliminate debt. Had it been available, Dion, such an option may have been an invaluable tool for those impacted by the 1990s collapse of several financial institutions that gave us fintech.
Julianne, you know you have our listeners listening now. Maybe some have even gone for pen and paper. Help us out. How can the Insolvency Act help to rescue, protect, and even rehabilitate an individual or a company facing mounting debt?
Well, what is new to Jamaican law is the concept of making a proposal. What I mean by that is where a person is generally unable to pay his or her debts when they come due, or reasonably foresees that happening within the next 12 months, then with the assistance of a licensed trustee, the debtor can consider making a proposal to his or her creditors, setting out how the debtor proposes to deal with the debt, and come to an agreement with creditors without the need for a bankruptcy order to be made or a receiver to be appointed over the debtor's assets.
So why is making a proposal to creditors under the Insolvency Act important?
Well, it is quite important. This process gives the debtor what is really a legal break for the sale proceedings. It's much like pressing the pause button, so to speak. It is a break or a pause from unsecured creditors and even secured creditors in certain instances, threatening and taking action against the debtor. So the effect of submitting a proposal, or a notice of an intention to file a proposal, if you're not quite ready with a proposal, is that once it is submitted, creditors are prevented from exercising any remedy against the debtor or the debtor's property and cannot start or continue an action in court or other proceedings relating to those debts until the proposal is fully performed. This means practically, for example, that a public utility company cannot disconnect water and electricity for the debtor's home or business for non-payment of bills, and landlords cannot terminate lease agreements for non-payment of rent if those bills or rent were owed before the debtor submitted that notice of intention to file a proposal document or the proposal itself. So sometimes that pause or breakdown from creditors may be just the opportunity that a debtor needs to regroup, strategize, recapitalize, restructure, negotiate, and live to fight another day.
What is the procedure, Julianne, for making a proposal in order to access statutory protection and rehabilitation for debtors?
Well, one common method is to drop off that notice of intention to file a proposal document with an office called the Office of the Supervisor of Insolvency, which is located on Grenada Crescent in New Kingston. This document may, and the following proposal must, be prepared with the guidance of a licensed trustee. This then buys the debtor some time, although not indefinitely, creating that break or pause button I had mentioned earlier.
You mentioned trustee, a licensed trustee. Can you share with us who is a trustee and how does that person help the proposal process?
Well, a trustee is a specially trained and licensed professional who must be hired by debtors to assist the entire proposal process. They're instrumental in providing advice to the debtor, preparing the proposal documents as outlined earlier, ensuring the law is followed, and help to fairly negotiate between the debtor and the creditors to resolve the matter, if possible. As part of the proposal, the trustee can even recommend to creditors that the debtor receives counseling. So the trustee would ensure that the proposal has all its supporting documents, like statements of assets and liabilities and cash flow statements. Then the trustee convenes a meeting of creditors to consider the proposal fairly. The law does not require creditors requires creditors to consider the proposal, but it doesn't oblige them to accept it. So during this meeting, the debtors, with the trustee's help, try and convince the creditors to accept the proposal as the better alternative to what in effect is a fire sale in the winding up of a company or liquidation of a bankrupt asset.
You're listening to Julianne Mais Cox, a partner at DunnCox Attorneys-at-Law. And I'm going to ask you, what about the creditors who hold the title to our homes, Julianne, a car or some other asset? For example, does the proposal temporarily stop a bank from selling your property under a defaulting mortgage or from repossessing your car even?
Well, those types of creditors are called secured creditors, Dion, and there are certain circumstances where the proposal can operate to create a break or a pause against secured creditors' proceedings. But the proposal process will not create a break or pause against, one, secured creditors who already had possession of the debtor's asset before the notice of intention to file a proposal was submitted. Secondly, secured creditors who have the debtor's consent or agreement to enforce their security, of course. And thirdly, secured creditors who file a notice of intention to enforce their security 10 days before you file your notice of intention to file a proposal. And fourthly and lastly, a secured creditor class of creditors that were not specifically included in the proposal itself that had been filed.
So if the negotiation goes well, what happens after the proposal is accepted?
But once a proposal is approved by the requisite majority of creditors, there is still a small window of opportunity for a creditor to make objections to the court against an approved proposal. This is because a court will not approve a proposal that is oppressive, unfair and unreasonable to creditors, is not calculated to benefit creditors in general, or where the debt is a company with employees, the proposed sums are not at least equal to what the employees would have gotten if the company was wound up. If no creditor objection is made within the time frame, then the creditor-approved proposal is by law considered to have also been approved by the court, and it may be then implemented by the debtor.
Well, what happens to the debtor if the proposal is rejected?
Well, if the proposal process does not work or a debtor files a notice of intention or the proposal and doesn't follow through with it, then a declaration of bankruptcy or receivership will follow, and the debtor may be released from most debts. The trustee will also be important in this phase, and it is recommended that debtors obtain legal advice to fully appreciate the consequences of such a declaration. And I should just add that in the bankruptcy process, there are certain types of debts that you will not be released from. Those include certain court orders or agreements relating to spousal support and child maintenance, civil court orders in specific cases, or debt liability arising from financial crimes or improprieties. I do hope that this has given listeners a brief overview of the temporary shelter the law provides to some debtors facing bankruptcy, giving them perhaps some breathing space to possibly reach an agreement with their creditors.
Julianne Mais Cox, a partner at DunnCox Attorneys-at-Law, helping us today with the legal shelter for debtors offered by the Insolvency Act. We certainly hope it's been of benefit to you today. Before you go, Julianne, can you give us any hashtags did you know?
Well, it's a hashtag, but I know it's been sort of played out in the media what's happening with, Mystic Mountain, the tourist attraction in St. Anne.
Yes.
If those who have been following that story would see this process played out. Mystic Mountain had filed their notice of intention to file a proposal in February 2021. That stopped the secured creditor during that time from realizing the security, but of course, in February 2022, its proposals and amended proposals were eventually rejected by creditors. They were unable to reach an agreement, and it is now in receivership.
Well, it's life,
so
isn't it?
It doesn't always work.
Yes.
But it did give them that breathing space to at least try.
Yes. So it's life when it happens, and it's here for some of us. We want to thank you so very much for guiding us through the Insolvency Act, and we look forward to another legal landscape next week. Always an interesting topic. Thank you, Julianne.
Thank you very much, Dion, and to your listeners.
Thank you. A pleasure having you. Join us next week. This week, our guest was Julianne Mais Cox. She's a partner at DunnCox Attorneys-at-Law. We certainly hope you found the topic today